Hello, everybody. Good evening. Hello. I'm on just a little bit early tonight just to make sure everyone gets their notifications. Hello, hello, hello. Welcome, welcome. Good to see everybody. Hello. Hi, hi, hi. We have lots to go through tonight. I hope everyone had a great Labor Day. Oh, thank you so much, Bobster. I appreciate that. Oh, good evening. Good evening. Hello, hello, hello. Good to see you. Welcome. Hello, Maura. Good to see you. Yes, I'm on. Yes, I am on. I'm on a little bit early tonight just to give everyone a chance to get their notifications. So I'm starting just a little bit early, but welcome in, everyone. So, yes, it's good to see all of you. Hopefully, you were able to celebrate today. Hello. Oh, hello, Florida. Well, welcome. Good evening, everyone. Yes, and playing games. Well, that's very important. Let the circus restart. Oh, I know, right? Oh, there's just so much. There's so much going on, for sure. Lots and lots that have been going on. St. Louis, well, hello. Heard you got some thunderstorms. Do I have a backup account? I do have a backup account. And I don't know, about every few weeks, I post something just to let everyone know where it's at. I have had a lot of I don't know, there's spammers or bots come in and who have said that they're me and they're coming into a lot of my videos and trying to pull a lot of people in. So that's not me. I will do a post. Atticus, what are you doing? What are you doing? Stop. Sorry, that was my cat. Oh my goodness gracious. Oh, I hope he calms back down again. But he really likes his food right now. That's his favorite thing ever. Oh my goodness gracious. Yes, so what was I saying? I can't remember. It was so long ago, those 30 seconds ago. It was so long ago. Yes, only stay for 10 minutes. That's okay, Stephanie. That's all right. I will have it posted up on my Tube of You. I'm just a little bit behind, so I'm going to start needing to do double posts to kind of catch up. So, but I'm hoping to get everything kind of caught up here pretty soon with that. Come here. Yes, what are you doing? You silly kitty. You want to say hello? All right, I'll bring him to say hello to everybody. Say hello. hello. He's just not even moving. He just wants to lay down. Oh my goodness. Yep. Yep. He's just running around. Yep. He wants to go play with Pearl. So off he went to go play. Oh my goodness. Yes, he's been very mischievous lately. Oh my goodness. Yes, it would. It would be fun to see his paws do the reading sometime. I don't know, maybe. He is such a koala bear. He's a snuggler, so he's just he may just like lay down, but we'll see. Yours is hiding from the kids. Oh my gosh, that's so fun. Well, yes, happy Memorial Day. Absolutely. You're not a very serious lawyer. Well, I am when I need to be, but when I don't, I don't. That's pretty much my philosophy in life right there. Yes, indeed. Oh my goodness. So tomorrow should be very interesting in New York, everyone. We do have closing arguments that should be presented and then charges to the jury, and then off they go. So we should have some deliberation going on there. Used to love to lay my... Oh, I know. So I went to... Where did I go to law school? I went to an accredited law school. So that's how... I keep the rest kind of to myself. But yes, I did go to an accredited law school. Still paying the loans back for that. Happy to do that, though. But yes, so we should have one case to the jury very soon, and then within the next couple of weeks, everyone, we should hear back on the immunity case. So, oh, thank you so much, Chaos. Yes, good afternoon, Mary. Good to see you. So, We should, I would say probably in the next couple of weeks. And then once we get the decision back, we're going to hit the ground running pretty good out of DC. So once that DC case picks up again, between DC and Florida, it's going to be a pretty busy summer, I would imagine. Oh, thank you so much. Thank you. Yes, I've got kind of my springy, summery nails for tonight. So welcome in, everybody. I am a little bit early tonight just to hop on and make sure everybody was able to get their notifications in time. Yes. Oh, thank you. Oh, I'm happy. I'm happy to spend the evening speaking with you all and hanging out. I do love talking about the law. Hello, really? Taco? Oh, I will. Okay, let me write that down so I don't forget. Oh my gosh, if it's got taco in the title, it's got to be great. It's got to be great. Long hot summer. Oh, I know. It's going to be, yeah, it's going to be busy. It's going to be a busy one. Hello, Grammy. Good to see you. Welcome in. Welcome in. Yes, so it will be a very busy summer, everyone. And again, once we get that decision from the SCOTUS on the immunity question, we'll be able to proceed forward on the DC case. But tonight, everyone, I'm wanting to kind of update everybody about where we're at in the Florida case. It's kind of been in the news lately. The last few days, there were a few documents that were unsealed, which was fine. All parties were fine with that. But when that happened, some of the information, I guess, kind of hit the press a bit harder than I had expected. And we also have some filings from defense that are pretty harsh filings, actually, against the prosecution. So we've got those filings that were done, and by Mr. Blanche. Really good nail polish. Ooh, I love that. I love that. Well, I'm all about the nails, everyone. So that hit the media a little bit. So I will kind of update everybody about where we're at on that, and then we have a request for a gag order now, an official gag order. We did have some protection orders already put into place in the Florida case, but now we've got an official request that certain information not be said. So I think it will be interesting to see how Judge Cannon comes back on that. But welcome in, everyone. So good to see you all. Now, just as a friendly reminder, in the Florida case, we have a superseding indictment, which means we had a second indictment that was filed. This is the original indictment, and then the superseding indictment added Carlos de Oliveira to it. So we had multiple charges here. I'm sorry, that's the District of Columbia, everyone. Look at that. I had the District of Columbia, and I was like, where is co-defendants? Oh my gosh, hold on, let me go grab the Florida one. Oh my goodness. I'm getting all of the indictments mixed up. No! Oh my goodness. All right, hold on here. Let me see, which folder did I put that one in? All right, just a second. I'm sorry about that, everybody. All right, hold on here. Let me see. Oh my gosh. Oh my goodness. All right. So that's New York. Hold on here. Let me see if I've got the superseding indictments right here. Okay, here it is. This is the regular, and then the superseding one. Nope, that's another New York. Okay, hold on here 1 second. Let me see if I can get. No. All right, just 1 second, everybody. I apologize for that. All right, here we go. We'll go with this. Everyone will know what I'm talking about when I show it to you. Sorry about that, everybody. Hello. Yes, sorry, that's DC. So here's the Florida indictment. This is the first one. The superseding one does have de Oliveira included on that. A couple more counts were added onto that, and so on. So yes, I came on a bit early tonight just to make sure I was able to give everyone their notifications. So the whole crux of this case has to do with the Espionage Act, right? So that's 18 United States Code, Section 793, which is gathering, transmitting, or losing defense information. So we've got counts 1 through 32, all covered by this one section of the code. Do I have Biden's? Hunter Biden's? Absolutely, I do. I've gone through his multiple times. And in fact, I am planning to do another live very soon because Biden is set for trial in just a couple of weeks. So stay tuned because that's fascinating. That's a fascinating case. So the answer to that is yes, of course I do. So we've got counts 1 through 32 under this section of the U.S. Code here. And because this is classified information, we have a lot of extra steps that we have to take in order to keep the information classified as we go through this. So with that, we do have a brand new schedule that was set. Now, if everyone remembers, we were actually set for trial this month. We had an omnibus order, scheduling order that had set us for trial. And then we had another order that came out from Judge Cannon here, and this order came out May 7th. So just a few weeks ago, and she set out our new pretrial schedule. So let me take everyone through first this pretrial schedule, and then we'll kind of go into the docket with that. So, it's a Florida night. It certainly is. It certainly is. Yes. So, and everyone can feel free to come and learn. I do try to, there's some serious angsty lives that you can join if you're up for that. But we just try to keep it at an educational level here. So hope everybody can understand that. My moderators are amazing, and I'm thankful for them so much. I've spoken with each one of them, and they all know kind of the parameters of what I'm hoping here, because we do try to keep this educational. When it comes, we've got the trolls. Yes, so sometimes we have a troll hunting night. We do go hunting, but we don't really have the... Just here for the facts. Absolutely, absolutely. We're not really hunting trolls tonight. We tend to, our philosophy here tends to be if you deprive a troll of oxygen, then, that's one way to get rid of it. So that tends to be kind of the way that we go after things here. So also you can remove the comments from your screen if you just want to listen as well. So that is another option. All right, so here we go. Let's dive in, everyone. I want to start with the most recent pretrial deadline scheduling. You're absolutely welcome. You're absolutely welcome. Now, again, I do want to get into the most recent brouhaha regarding the search warrant, Mar-a-Lago, and all of those things, but I think it's important for us to kind of recognize here what we've got going on for dates. So we will start... here with this scheduling order. We've got a sealed hearing on grand jury matters. This took place, it was a telephone hearing on the 8th, and this is when things started to get kind of heated up in the Florida case, because there were some questions about the defense counsel was claiming there was some misconduct, and that of course was taken care of. But because of that, things the relationship, I think, between defense and prosecution has taken a turn here. So we'll have to see how that goes. But so far, it's not looking good. So we have a resolution on pending seal requests. So the sealing of multiple documents had already been requested. And so we had that on the 20th. And then a non-evidentiary hearing on defendant Nada's motion to dismiss for selective and vindictive prosecution. So this was another one where we kind of had that big brouhaha. It's a non-evidentiary hearing where there was some discussion that perhaps people had raised their voices, and it's possible that that did happen. Non-evidentiary hearing on defendant's motion to dismiss indictment for insufficient pleading. And this has to do with a filing from 352, and what's so interesting is that this is actually not public, this 352 filing. So as we go through this, to keep everyone kind of up to date, the electronic filing number is listed here, and Judge Cannon really relies on these numbers extremely heavily in her docket. Her docket is a mess, all right? And so she really relies on these numbers. Each one of these numbers corresponds directly to a filing. So, for example, here, 352, which was not actually available to the public, but here is a filing here. This is Trump's motion for relief relating to the Mar-a-Lago raid and unlawful piercing of attorney-client privilege. So this is his filing, and at the very top, it states that it's document 566 when it was entered, which was May 21st. And this, of course, is the case number over here. So this document number up here, that is what Judge Cannon refers to throughout everything that she's doing. So ECF is that document number at the very top. So that's what they're saying here about this particular document that they're wanting to get taken care of. Next, we have a discovery status report on May 31st, which is due, which I just saw, if I can pause for a second, I just saw, let me see, I don't think it was a discovery, maybe it was, let me see. We have a joint status report regarding sealed filings. So we do have this that has been filed, and this was filed on the 20th, but they are waiting to have the status report should be on May 31st. So that's kind of coming up here. Again, I'm just doing this overview before I really start cracking into this docket here, everyone. Next, we have the defendant's Rule 16 expert disclosures. So the defendants, any of the experts they're going to be using, those are due by June 10th. The SIPA Section 5 notice as to all defendants are June 17th. Now, SIPA is the Classified Information Procedures Act. Because this does involve the Espionage Act, because it does involve classified information, we have a special statute that governs how we deal with these kinds of documents. And we just refer to it as SIPA, and there's different sections regarding the procedures. Because again, that information is classified, and so we have to be careful about it. So this notice is June 17th, non-evidentiary hearing on a motion to dismiss indictment based on unlawful appointment and funding of special counsel. That's going to be June 21st, and then a partial evidentiary hearing on defendant's consolidated motions to compel discovery. So the defense has filed multiple motions to compel discovery for quite a period of time. Each time the government has come back and said, we're giving you all of the discovery, and so there's this ongoing fight. So there's going to be a hearing about that. How can they call it a raid in a legal document if it's actually just a search warrant execution? Well, that's a great question. They can really call it whatever they want, and that's kind of triggering. It's kind of like bad form. As an attorney, I would look at it kind of like, technically, I suppose you could call it a raid because everyone knows what you're talking about in your legal document, which is the whole point. But it's kind of like the person who plays by the, like the down and dirty rules, like the people that you don't want to play with because they break the rules, like they don't play fair. That's like kind of a crappy way of doing it. So that's kind of how I see a lot of Mr. Blanche's filings, is that rather than, playing by the rules that all of the attorneys need to play by, he kind of plays by dirty rules. So I'm not sure why he feels the need to do that, which unfortunately tells us a lot about his attorney style, I guess. But yeah, so that's kind of something that is unique to attorneys that apparently don't care any longer about their reputation anymore. So, of course, you can use inflammatory words when you're filing things, but in this kind of a situation with what happens at Mar-a-Lago and that whole situation, this entire filing is inflammatory, and it's not meant for the court. This is meant for the public in order to kind of stir everybody up. So that's kind of, unfortunate. It's one of those things where you're like, ooh, he's kind of one of the sleazy ones, I guess is how I would put it. I would not have imagined myself saying that about Mr. Blanche at the beginning of all of this last year. Many of you have been with me for over a year now, since I started coming on and reading all of these documents, but I never would have imagined that we would get to a point with his filings where they had really evolved into, really like, it's really quite unfortunate. It's really too bad, I think. So, yeah, I'll get more into that as we go forward. He's like, Trump follows his own rules. Well, it's interesting because, my understanding was that he was actually a paralegal for a while, and and went to school and worked really hard and actually was quite respected. And so this is really a situation where, there was such potential there. And just based off of what I see him filing and how disrespectful and crass and he's like the guy that would just throw dirt in your eye instead of having a good, fair fight, and it's like, ugh. So it's just really unfortunate. It's very unfortunate. So, all right. So then next we've got June 24th through the 26th, partial evidentiary hearing on defendant's consolidated motion to compel. Again, so we've got all those motions to compel, which I'll talk about those in a little bit here. Special counsel supplemental expert disclosures, if any. So special counsel has already filed on their experts. And so if there's any additional filings, those are due July 9th. Special counsel SIPA section 6A defense reciprocal discovery then is July 10th. So again, what you'll see with SIPA is that we're going section by section by section because that's required by the rules. Then we've got defendant's combined speedy trial report, July 19th. And so that's the moment in which we will find out what needs to happen. When are we going to have a firmed up trial date? And I believe that that's the latest at which we will have that date put into place by Judge Cannon. We'll have a status conference on July 22nd. Then that supplemental SIPA Section 4 hearing on July 22nd. So this is where we will get our official trial date. Is my guess based off of what she has written here. Pretrial motions excluded from speedy. So pretrial motions are woven into all of our speedy requirements. Now, in this case, we have a very strict speedy schedule, and Judge Cannon is very aware of that. And so basically every month, let me see if I can find that here, the latest speedy. Every month, the government files a speedy trial report and puts on the public docket and for Judge Cannon the status of speedy. So let me just grab the most recent one. I think we're on 16 at this point. Let me see where I have it. So again, every couple of months they file one. I think it might be every month. And then with that, what happens is they count how many days are left in the speedy window and tell us what's going on with that. Wow, where did I put that? I tell you what, I started with the, I started off with the DC indictment. I think it's just throwing me for a loop here. All right, just 1 second here. That is so bizarre. Let's see here. Oh, here it is. Look at that. It's right under my hand. Oh, can't find it because I was holding on to it. I had it in my hand. Of course I did. All right, 16 speedy trial report. So there's a local rule, 88.5, and because there was an order that was set out very early, saying that the government has to set out the speedy trial report. So this happens again multiple times. So what they do is they go through and they explain how the time is running, how it's tolling. So I think the easiest way to set out where we're at as far as speedy goes, in its July 21st order granting in part government's motion to continue trial and resetting deadlines. So July 21st, so last year, the court excluded all of the time between the date of that order and the trial date of May 20th of 2024. So that's why we had our trial set for the date that it was set, was because that was when the order had moved the speedy date. So pursuant to a federal statute, by order of August 21st of 2023, the court extended its earlier order to defendant De Oliveira. Last by order dated September 13th of 2023, the court confirmed that the same speedy trial clock applies to each defendant that has been told until May 20th, and that 70 days remain on the speedy trial clock. by order of May 7th. So this is when she reset everything here. As you can see, the order I just took you through is dated May 7th. So she set out here, the court further excluded the time between May 20th and July 22nd. So all she did, everybody, all right, is she took 2 more months. She moved the goal down 2 months. So within 2 more months, so again, that gives us that July 22nd date, and that's when the speedy clock starts again. So she has to set a trial date and deal with the 70 days of trial, the 70 days of speedy by July 22nd. All right, so this whole idea has been that she's been pausing the clock. Speedy's not been waived officially, and the government has said we have a right to speedy also. So what she's been doing is she's been saying, I'm going to pause it. She paused it to May 20th, and then she issued another order, and she said, I'm going to pause it until July 22nd. So she just paused it for 2 months. And then after that, that's when the speedy clock starts. And so that means within 70 days, the trial has to be onto the record, or else you will lose, you'll lose it. Your case will be toasted. So that trial has to happen 70 days after May 7th. No. So what happens is she's resetting. She reset the excluding of the dates. So the time that was reset here, she had, all right, so she had started the speedy clock on May 20th, but by her order on May 7th, she said, I'm going to pause the speedy clock. I'm going to let it go until July 22nd now. So she just moved the clock. She just moved the clock down 2 months. So it's 70 days from July 22nd. They have to have the trial. Within 70 days of July 22nd. Yes, Anthony. October 1st. Right. So here's the deal. It's possible, everyone, that once July 22nd comes, basically she will have had all of these hearings that she wants to have. She'll have all of these different documents and everything filed. So she'll be able to assess when the most appropriate date for trial is going to be. So she's going to start the speedy clock again July 22nd, which technically is, I think, maybe 2 weeks after Jack had requested the trial to start. So it's actually before defense wanted the trial and right around the same time that Jack did. So the speedy clock can get reset again. She can reset it at this point and say, we're going to pause it for 2 more months. That's absolutely possible. But as it's set right now, the trial has to occur within 70 days of July 22nd. On how many times the goalpost can be moved? Great question. And I would say there comes a point, when to exclude the amount of time does get to a point where one of the parties is going to file on it. Now, the reason why she has stated this is because based off of the defendant's filings, the speedy date has been granted permission to be moved. But you have to have that permission from the parties. And once we get past September, technically, that's when the last permission was really given. So it has to be at a point before that permission runs, or else the parties then can file against it. What happens if she doesn't adhere to the speedy trial clock? Well, she would. That's a fundamental. If the speedy trial clock runs without the trial actually going, then the case is gone. The case is dismissed, and if it's because of the judge's error, then she's done. Her job is over. I wouldn't say mistrial; it's just dismissed. Yeah, the case is just you cannot file. If you miss speedy, you're done. Your case is over. That's one of the constitutional rights that you have, is that it has to be within the confines of speedy trial. Now, what speedy trial means is different in every jurisdiction. But if a judge misses speedy, you're not a judge anymore. You're over. Yeah, you're done. She will have lost her position. That's like malfeasance. That's huge. And honestly, she would lose her law license. I've seen a lot of people. If you miss a deadline like that, she would no longer be able to practice. They have to refile from scratch. So great question, Hitch. So the thing is, if you miss the speedy trial, it's not like a voluntary dismissal and you can refile. If you miss the window of speedy trial, you can no longer have that same case because your case is barred constitutionally by the statute of limitations, or not by it's by the speedy trial rules. All right, so you have to bring your case to trial within the speedy window, or else if you don't, then your case is gone. And it would be unconstitutional for you to be brought back into court for that same case because it was not brought within speedy. So that's a constitutional violation. Who moves the judge if she misses it? Oh, that's a good question. I would imagine the chief or her boss in that area. Yeah. Is it the same for civil cases? Now, that's a great question. And no, it's not in general. Every jurisdiction has their own rules for civil cases. So depending on your civil case, it will tell you when things need to be done. But constitutionally, you're only guaranteed that right to a speedy trial for criminal cases where your freedom is in jeopardy, your freedom or your life. Why is she doing this? Well, I think it's because she just is completely inexperienced. Right, they won't violate. Well, right, it would be a constitutional violation of your right if you had a trial that was not brought within the speedy trial window. That would be a violation of your constitutional rights to a speedy trial. All right. So that's why a lot of people say if you don't waive speedy and your case has to be brought in 90 days and the prosecutors don't bring your case in 90 days, then your case is done. It's over. They cannot bring that case against you because they missed the speedy window. Have you ever seen that before where speedy ran out? I've seen speedy run a few times. Usually speedy, well, unfortunately, speedy can run if there's some question on the actual date of when it starts. Speedy can run if you actually can't find the defendant and, maybe they post bond, they have it waived speedy, they post bond and then they jump. So then the question is, when does the speedy clock stop? The other thing too is if you've got a prosecutor who's got too big of a caseload and they're not paying attention to the calendar and something falls through the cracks, yeah, you can lose a case. Then your job's over. I mean, you can lose it. And this is why they haven't waived it. So, Thomas, that's a great point. But I think both sides here, both the government as well as the defense, have both said, we're not willing to waive speedy. We're not waiving any rights here. And so kind of a compromise that Judge Cannon did was she set that May 20th date. And so when she reassessed that situation on May 7th, she's like, I need to bump it 2 more months in order to figure out when an appropriate trial is going to be. So she bumped it 2 more months based off of a filing, specifically the filings of both Jack as well as all the defendants when she asked them to make filings on when they wanted trial. Jack said sometime in July. I can't remember who it was. One of the defendants said August is fine. Another 2 defendants said September. So based off of those filings, she set it to July 22nd to start again, meaning she would need to have a trial date set by then. Right. Judge were willing to sacrifice their career. They could just let... Right, but it's not just your career. I mean, you swear an oath to the Constitution when you when you become a judge. It wouldn't just be your career. You swear an oath that you will uphold the Constitution, and one of the constitutional rights is to a speedy public trial. So that would be intentionally violating the Constitution. I mean, there's not a lot of situations where you're like, oh, I can intentionally violate the Constitution, but this would be one of them. When you know full well you are violating speedy and you are intentionally, personally going against the United States Constitution, I mean, that's huge. That's huge. If it slips through the cracks, that's one thing. But if you're doing it because of some kind of intent, that's another thing. That's a whole nother thing. I'm not saying it's not possible. I'm just saying that's a whole nother thing. Actually been to prison for perjury. Yes. Oh, well, I mean, Wesselberg's in prison right now, right? She isn't, well, right. So she can be charged if she deliberately does it. If she intentionally violates her oath as a public officer, there could be some pretty significant repercussions, yes. I don't know exactly what the rules are. I don't know exactly what the law says, but yes, there could be some. If she intentionally abuses her position of authority and intentionally violates the Constitution in order to somehow benefit somebody by throwing all of this, yes, she could absolutely be charged. Bar license at a minimum. Absolutely, at a minimum. Well, right. I mean, it's intent would be something where you would need to show that she intentionally did it. But I tell you, with so many eyes on this case, there's no way that this is going to just slip through the cracks. There's just too many eyes on the case. So she would have to, the only way that she would be able to mess with Speedy is if she did it intentionally, everyone. What about the people's right to a speedy trial? That's another part of it, exactly, Django. And that's another reason why we have the dates that we have, is because Jack argued, and I thought he argued very well, both in DC and here, that the people also have a right. And so they're like, okay, let's take care of it then. Any defendant can say they want a speedy trial and then run away. So good question. It depends on how your rules work. If you say you want a speedy trial and you run away, in some jurisdictions, then it stops the clock. Once you get served, your clock starts again. Once you get arrested, your clock starts again. It will depend on your jurisdiction. But there have been some instances in the past where when someone has run, there have been issues with speedy. So I was just giving those as examples of where speedy could be an issue. But 99.9% of the time, if you run on a speedy, everything just pauses until they serve you a warrant. Yeah. Wednesday, maybe Thursday. Could very well be. It's absolutely possible. All right, everyone. So that's kind of the update there on the speedy. Now, I know everyone was really frustrated when, and as I was as well, when Judge Cannon came out and said, I'm not going to set down a trial date. And I know it was very frustrating, but also if you count out speedy and take speedy into consideration, it can't go on forever. It can't. It's just not constitutionally possible. Speedy is only in criminal cases. We have a statutory authority that will set out the rules for deadlines or timelines on civil cases. But the only thing for speedy in the Constitution is for criminal cases. Great question. All right, so she can rent it out. She absolutely could get away with it. Oh, I don't know, Bruce. I don't know. That would be a lot. I mean, I get it. I know a lot of people are very frustrated with her, and understandably so. But I think a person who's worked her entire life to get to this point in her career to intentionally violate speedy, one of the most basic rules. There's just a lot of other much easier ways for her to get this case tossed than to screw up speedy. There's a lot of easier ways, I guess, is what I'm saying, to do that. So, oh my gosh, yes, make sure if there's a tornado. Oh my gosh, yeah, take care. Oh my gosh, goodness, be safe. Trump would pardon her. Well, it doesn't matter if he pardons her or not. I mean, she would never work again in the legal field. So, I mean, if she gets pardoned, she could work at Target. There's nothing wrong with Target. I'm just saying. Who would know if she was doing it on purpose or not? It'd be pretty easy to prove in this kind of a case because it's just so well watched in this situation. All right, everyone. So let's kind of pick up where we left off then. The last time. Now, it's been quite a bit of time since I've done an overview in the Florida case. And so I'm going to try to pick off where we left off. Filed for her to be dismissed. No, not yet. There just have not been grounds at this point. Why the trial was stopped for him? If the offender had already been jailed. We just don't know that. We just don't know that, everyone. We just don't. You might think that that's true, and it could very well be true, but we don't have any proof. So, please be a law-abiding citizen so that we don't have any proof of that. Thank you. About pardons, I think they can pardon anyone. So that tends to be something actually that was pretty old school. That was a technique old school used where people would dangle pardons in front of other people to get them to do what they want to do. Very, mobster-esque, especially back in the Prohibition days. So it's making a comeback, apparently. So the last live I did was the Speedy Trial Report out of April 5th. So let's move forward here. And hello, Kate. Good to see you. Thanks for joining. So we've had a few hearings that have come up. We've had a few. Well, the judge is not attacked. Well, I mean, he did go after her a little bit. He's just not gone full attack mode here, for sure. We've got several amicus curiae briefs that have been filed, everyone. For those who are wondering, an amicus brief is a friend of the court brief where an outside person says, I've got valuable information for you, so I want to show it to you, Judge. She's accepted some, has not accepted others, so it just kind of depends on how she's feeling about it. You like to jaywalk? No, Thomas, no. Well, I mean, all right, well, be careful. I mean, if you're jaywalking but nobody sees it, it's still a crime. So, but, are you going to get caught? That's a question. So and that's not legal advice, just clarifying. So let's go to my first piece here I wanted to talk to you about. We've got multiple orders in here where we have some of the filings that have been unsealed, everybody. The first one is here, and this is document 472, where she sets out, this is her paperless order, and she has set out that documents 101, 115, 116, and 118 are to be made public. So there are a lot of sealed documents in this case. There's a lot of sealed filings. We do not have all of the information because of the nature of the case, and that's just kind of the rules. But she has slowly started to open up some of these different filings. Now, what's being reported is that she feels very strongly, not necessarily being reported, what she has written in her order, she feels very strongly that the public has a right to all of the information, no matter what it is. Now, of course, we know that that's not true, but that's what she's saying. So she's slowly going through and talking with both sides and talking about what can be released to the public or made public. So something that's very interesting that's not been reported on these filings that are being made public now, and we've probably heard about the search warrant question. We heard about several different things that have now been made on the public docket, right? Everyone's following me on that. One of the interesting things about this is that the government has filed, I think, four motions for redactions on multiple situations. For months, they've been filing. The first one they filed, the government's first motion was all the way back in the 300s. So they've been filing these redactions. It's just taken her this long to go through and unseal things. So it's not like all of a sudden this is new information that they want to share with everyone. It's more of she's finally gotten to the paperwork. So we also have the unsealing here of 117 and 119. We're still kind of waiting on that. These have just become public or available for everyone to take a look at. And if you're wondering what 117, 119 and some of these documents are, it was a big fight over a grand jury testimony and in the situation that went with the grand jury. There were questions about ethical bad behavior. It got very heated. Now, one of the reasons I think that the information has become public now is because of the most recent filings for a motion to suppress by Mr. Trump's attorney, Mr. Blanche. So Mr. Blanche has taken this information that has now been made public, and he has put it into a brief, even though some of it is still not public, it's still redacted. And he has gone completely bonkers, in my opinion, and is saying that the evidence gathered at all of the search warrants information needs to be tossed on his motion to suppress. So this is really actually, it's disheartening to see that an actual attorney wrote this. I think I had thought, and I'd been holding on to this idea that perhaps, Giuliani had been doing most of the filings in this case, but at this point, I'm concerned here. Yeah, so let's take a look at this. let's just take a look. So this was just filed, everyone, on the 21st. The government has responded, so I will, of course, show you the response. But when you're wondering why things have gotten so heated in Florida, this is why. So let me take you through it. Again, this is the Mr. Trump's filing here. So they have filed a motion to suppress, meaning they want the evidence thrown away. A motion to suppress means there's a violation of the Fourth Amendment to the Constitution. It's the most pled motion in the criminal justice system. So here is what we've got. First, the Mar-a-Lago raid violated President Trump's constitutional rights. How so? Well, the decision to raid Mar-a-Lago, the warrant application, the general warrant, and the illegal raid itself. Applicable law, they say there's misrepresentations in the search warrant affidavits and the Fourth Amendment particularity requirement, which is set out by multiple pieces of case law. Next, the discussion. A Frank's hearing is warranted. The warrant lacked particularity again. The Mar-a-Lago raid was executed in an egregious fashion and in bad faith. Bad faith is a legal term that we use that is its own animal. So if something is being done in bad faith, then it means that everything is being tainted. It's very difficult to prove, actually, bad faith. Very, very difficult to prove. But, and it's kind of, again, when I was telling you earlier about when you're trying to have a good, clean fight with somebody and they kind of like cheat or they play like by their own set of like crappy rules, like they throw dust in your eyes or something like that. I'm trying not to use the phrase I'd want to use. But that's what this is legally. This is, you only go in the most extreme situations with the bad faith argument. Only as a last resort. It's like a Hail Mary situation. You're going to ruin your own reputation if you use it and you argue it in front of a judge. Right, revengeful. Yeah, I think that's a good way to put it. So that's the first piece. The second piece, the special counsel's office violated President Trump's attorney-client privilege. Relevant facts. May 10th of 2022, subpoena to President Trump's office. May 23rd, 2022, meeting at Mar-a-Lago. June 2nd and 3rd, 2022, meeting at Mar-a-Lago. The Trump Organization subpoena, and then we've got two redacted pieces here, subpoenas. Motion to compel, the compelled testimony. Next, applicable law, attorney-client privilege and work product. Next, the crime fraud exception. We've heard a lot about the crime fraud exception because the deal is you're not allowed to have attorney-client privilege if you are trying to partake of criminal activity. So there's that. Discussion here. Special counsel's office failed to make a prima facie showing. The communications did not further any crimes. The compelled waiver was overly broad. The court misapplied the opinion work product doctrine. Oh my goodness gracious. So these are their two big pieces that they're saying the evidence should be, all of the evidence gathered from the warrants should be suppressed because the warrant was bad, is what they're trying to say. Now, every single defendant where there's a warrant involved, you will probably see, oh, thank you, Elle. You'll probably see a motion to suppress. And because, again, it's the most pled motion in our criminal justice system, and rightfully so, because we need to make sure our searches are done properly. Very, very high standards, and they should be held high, and I agree completely with that. But do I agree with this motion? No. This motion is, again, in my opinion, bad faith on behalf of Mr. Blanche. I think this is frivolous, would be the other term I would use if I was to try to go and file some kind of a sanction against him. I would call this frivolous. So, yeah. So that's his filing. Let's see what the government said. So we've got the government did respond. And again, I'm showing you this to kind of let you know why things are so heated in Georgia and why we have this issue with the warrant going on right now. So here is the government's response. The warrant to search Mar-a-Lago was valid and lawful. Background, the warrant to search Mar-a-Lago. Number one, the warrant affidavit. Second, issuance and execution of the warrant. So I take you through that. Trump's suppression arguments lack merit and he fails to meet the heavy burden to obtain a Frank's hearing. From what I can see right now, bad faith is all that Blanche. Yes, it's really quite unfortunate. You know, when you see somebody in your own field that's a complete I don't want to say used car salesman because there's nothing wrong with being a used car salesman, and I've met some nice ones, but like a big jerk. like a cheater, pumpkin eater. He's a cheater is what he is. That's how I view it. The warrant affidavit contained no misleading omissions, let alone misleading omissions that were intentional or reckless and material. The warrant stated with ample particularity the place to be searched and items to be seized, which if you're going to go to a former president's home and search, you're probably going to be pretty careful about your warrant. What's a Franks hearing? So the Franks hearing, I think, this is a hearing that is set out in federal court. Let's just read into what the government says here. All right, so the Fourth Amendment provides no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and persons or things to be seized. Right, Trump contends that the warrant at the search of Mar-a-Lago failed to meet the probable cause requirement because of the supporting affidavit contained omissions that were intentionally or recklessly misleading and material to the magistrate judge's probable cause determination, warranting a hearing under Franks v. Delaware. So basically, a magistrate judge has the authority to issue a search warrant based upon probable cause. So an officer can bring in probable cause, give it to the magistrate, and the magistrate makes that judgment call. That's why they're a judge. And so they're saying that determination was inappropriate because it was intentionally, recklessly misleading. So they want to have a hearing to judge whether or not that magistrate's assessment of probable cause was appropriate. So that's what they're calling a Franks hearing because we're in federal court. All right. So that's the probable cause. Yeah, probable cause. Yep. But, and we've talked about this before when it comes to probable cause. Probable cause is not proof beyond a reasonable doubt. That's different, right? We have three primary levels, and it's on a continuum. We don't have the first, we have reasonable suspicion. These are our burdens. Reasonable suspicion to believe criminal activity is afoot. And then we have probable cause. Probable cause to believe that a particular person committed a particular offense. And then we have beyond a reasonable doubt. All right, so that's how you get a conviction. If you're wondering, the civil element would be here, and this is upon a preponderance here. So that's kind of over in this area. So if you're saying, well, what exactly is probable cause? I cannot tell you. I would say based off of the totality of the circumstances, based off of the experience of the judge and looking at all of the factors, they will make this determination of probable cause. Reasonable suspicion is a very quick and dirty out in the field, what's going on. Based off of my years of experience in the field, I believe, this person has a weapon. And so that's a reasonable suspicion. Or probably more familiar to people would be the stop and frisk standard here. Probable cause is a higher burden. Now, if you want probable cause is what is required for warrants, that's in the Constitution in the Fourth Amendment. Probable cause is required for any indictment. So if it's a grand jury, they have to indict on probable cause, or if it's some kind of a paperwork or an information or something like that, it has to be probable cause. If you want to do, I would say probably I'll just call it the automobile exception. The automobile exception to the warrants. So we have an exception when it comes to cars. It's also known as the Carroll Doctrine. I don't want to get too specific here, but that also requires probable cause. All right. So we use probable cause a lot in the field. Probable cause is just, like the air that we breathe. So what they're saying is you don't even have a minimal level of probable cause. Also, it's what's required for a preliminary hearing, by the way. Let me just add that in on the legal side as well. Preliminary hearing. All right, you can waive your preliminary hearing, of course, if you choose to, but if you don't, they have to show that there was probable cause to bring you in this situation. All right, so probable cause plays an important role. So if they're saying here there wasn't probable cause for the magistrate to issue the warrant, then that's a pretty big deal. And it can happen. I'm not going to tell you it doesn't happen. It absolutely can happen. A warrant A judge can make a mistake. A magistrate can think that there is probable cause and there actually isn't enough probable cause. That can absolutely happen. But that's the exception. That's not the rule. So I would say here, in this case, when they're getting ready to go to Mar-a-Lago, I would say the one thing they're not going to screw around with is having enough probable cause. But, whatever. All right, so next up, the evidence from Trump's attorneys does not warrant suppression of or dismissal. Here's the background. We've got a summary of select evidence, the crime fraud litigation in the District of Columbia. The crime fraud exception forecloses suppression. So this means, again, crime fraud, meaning if you and your attorney are criming, then you are not going to be able to use that attorney-client privilege. The evidence readily establishes a prima facie showing of a crime. The attorney-client communications work product furthered and was closely related to the crime or the fraud. And again, what is so interesting here is, we have attorneys involved in the DC case, right? We even have an attorney in the Florida case where he looked through, saw that there was classified information, took it and put it in a red folder, wrapped it in packing tape, and then put it in the safe in his hotel room. That was his attorney. Yeah. So is that information privileged? No, because there's a crime going on there. And that is the possession of classified information you don't have authority to have. Next, Trump's characterization of the evidence as opinion work product does not support suppression. Trump provides no basis to dismiss the indictment. So this would be the government's response. I think it was well written. I think it was as well. Oh, yes. Oh, yes. There were several attorneys involved. That's why we keep going around and talking about this crime fraud situation. We have one attorney who signed a statement saying we've given the FBI all of the information that we have, which was not true. And she didn't have proper information for that. So she's got a problem with that. And then we have this other attorney in here who's like, wow, I think there is some criminal activities afoot. I want to do the right thing. I'm not sure what the right thing is. It's the middle of the night. So we've got lots of things that have been going on with multiple attorneys here. So if Mr. Trump is trying to say, you can't use any information from attorneys involved in this case as witnesses because they're my attorneys and the attorney-client privilege protects me, that's not true because there was criming involved, and so none of your attorney-client privileges will attach because of that. Oh, thank you, Larly. Appreciate that. So that's how things are getting, and they're getting pretty spicy. They're getting very spicy in Florida. All right, so these two motions have been filed at this point, and so I can take you to, with those filed, we've got, all right, so the motion to suppress by the defendant was filed here on May 21st with multiple exhibits. Now, these exhibits are a bit, very interesting actually. If you go online, everyone, and you pull this docket up, you can take a look at these exhibits. They're interesting exhibits. They actually tie back to some of the documents that were made public after this. So then we have the response here, which is what I just read. Now we have a reply to the response by Mr. Trump. Now at this point, the actual accuracy of the information, so I did not print that out. I can really only go so far with some of these documents. I'm gonna have to take a break. So he did file a reply. Then we have a notice of filing here. And we've got a motion for miscellaneous relief that was filed. We have also then on the 21st, a notice of compliance by the United States here. And then we've got a paperless minute entry. All right, so I'm just going to kind of take you through these last few pieces before we get to Jack's request for the gag order. All right, so we have a paperless minute entry for a hearing held. This was that very contentious hearing. Thank you, Tina. All right, here we go. Made an entry for hearing held before Judge Cannon on May 22nd. The court heard argument on defendant Nada's motion to dismiss for selective vindictive prosecution, and 2, defendant's motion to dismiss indictment for insufficient pleading, which again, I've not been able to find anywhere. I cannot find it. I have not been able to read it, and it's a bit frustrating, actually. Motions taken under advisement. So that's her holding. She has taken the motions under advisement. She had a full hearing and is like, I don't know what I'm going to do. All right, so on or before May 24th, parties directed to file sealed, unredacted versions of remaining items discussed for docket completeness, along with notices of supplemental authority in accordance with the local rules. Total time in court, 4 hours and 30 minutes. And then she sets out who was appearing there. So what she's trying to do is clean up her docket because we had a whole bunch of motions that had not been answered by her. A whole bunch of SIPA motions, a whole bunch of other motions. And so she's saying, wow, I'm overwhelmed. So I want everybody to just put it all together for me. Put together all of the motions that you've already filed and tell me what else needs to be answered, which is it's a rookie move. That's absolutely a rookie judge move here, having other people kind of do your work for you. One hearing for one thing and nothing done. Exactly, Jennifer, exactly. So next we've got a supplemental responses to the standing discovery order. This is the government here, notice of compliance here. And then we flip to the next page. Transcripts were made available, transcripts of motions here. And then we've got Jack's motion to modify conditions of release. And this is what what I have posted on. I did, I think, 4 parts, and I actually read through that motion for everybody. Where Jack came in and said, wow, have a little bit of respect for, people and requested that modification of the conditions of release for Trump because of what he said regarding the Mar-a-Lago search. So let me grab that motion real quick. Boy, I have so many papers this time, everyone. I'm struggling to get them all in the right place. Okay, here it is. We got it. Woo! Hello, Kristen. Yes, we got woohoo! Thank you, everybody, for the likes. Appreciate that. All right, so this is the government's motion for modification of conditions of release. So this is the final thing that's on the docket. So I was wondering, would you like me to go through that motion with you then? Is everyone interested in hearing what Jack wrote? Yeah, it will. Because I can walk you through that. Okay. Yes. Okay. Excellent. That's kind of what I had thought we could do here. Okay. Oh yeah. All right, well, let's go through this then. I let me see here. I just have this sticky note and I'll just kind of move it back and forth, or maybe I can put it down here. It's been a while. I'm going old school, everybody. We're going old school with the documents here. So this is the Florida case, Florida Ducks case, and this is the gag order request is what it is. So I will just put this here, gag order request, and let me bump this up like that. All right, how is that? Can everybody see that okay? Just want to make sure. Oh no, not the sticky note. Oh, I know, Jennifer, I was thinking of you too. I was thinking of you. No, I gotta get the sticky note out. I've got to do it. Okay, is it okay? Is it all right? Okay, good. All right, so let me just put this here, and then that'll help me stay centered a little bit. All right, so let me explain how this document goes then. I will read it to you, and if there are points to kind of go through, I will explain that as well. It's not a very long order, or not a very long motion. All right, so let me grab another pen here. All right, again, this was just filed on the 24th. Government's motion for modification of conditions of release. The government moves to modify defendant Donald J. Trump's conditions of release to make clear that he may not make statements that pose a significant, imminent, and foreseeable danger to law enforcement agents participating in the investigation and prosecution of this case. Then we have footnote 1. The government has contacted counsel for defendant Trump, who stated that they object to the motion and the timing of the conferral on a holiday weekend. It is their position that the government has not provided an opportunity for meaningful conferral. They do not believe that there is imminent danger and ask to meet and confer next Monday. However, within just the last few hours, Trump has continued to issue false statements smearing and endangering the agents who executed the search. Then we have a citation here. The government's request is necessary because of several intentionally false and inflammatory statements recently made by Trump that distort the circumstances under which the Federal Bureau of Investigation planned and executed the search warrant at Mar-a-Lago. Those statements create a grossly misleading impression about the intentions and conduct of federal law enforcement. Trump baloney. It's true. It's true. True story. Oh, my goodness gracious. Law enforcement agents falsely suggesting that they were complicit in a plot to assassinate him and expose those agents, some of who will be witnesses at trial, to risks of threats, violence, and harassment. The court has an independent obligation to protect the integrity of this judicial proceeding and should take steps immediately to halt this dangerous campaign to smear law enforcement. And as of the time I went on this live, there has been no immediacy done. All right. As Trump is well aware, the FBI took extraordinary care to execute the search warrant unobtrusively, and without needless confrontation, they scheduled the search of Mar-a-Lago for a time when he and his family would be away. They plan to coordinate with Trump's attorneys, Secret Service agents, and Mar-a-Lago's staff before and during the execution of the warrant. And they plan for contingencies, which in fact never came to pass, about with whom to communicate if Trump were to arrive on the scene. As part of this planning, the FBI used a form that contained standard and unobjectionable language setting out the Department of Justice's use of force policy, which prohibits the use of unaliving force except where the officer has a reasonable belief that the subject of such force poses an imminent danger of unalive or serious physical injury to the officer or to another person. They just filed a reply tonight too. Really? Motion to strike the U.S. motion. So they filed a reply? Oh my gosh. All right. Well, hold on. We'll have to see if I can get that printed out. Where did I put that computer? Hold on a second, everybody. All right. Well, let me finish this up and then I'll take a look at it. All right. Here we go. Wait, did I already read this part? Right. As part of this planning, the FBI used a form containing standard language setting out their use of force policy. The inclusion of that policy is routine practice to restrict the use of force, and it's attached to countless warrants across the country. Moreover, as Trump is well aware, no force was used or threatened in executing the Mar-a-Lago search warrant. Thanks, VC. As planned, the FBI executed the search warrant in a professional and cooperative manner at a time when Trump and his family were out of state. Trump, however, has distorted the standard inclusion of the policy, limiting the use of unaliving force by mischaracterizing it as a claim that the FBI was authorized to shoot me and just itching to do the unthinkable and locked and loaded and ready to take me out and put my family in danger. These deceptive and inflammatory claims expose the law enforcement professionals who are involved in this case to unjustified and unacceptable risks. They invite the sort of threats and harassment that have occurred when other participants in legal proceedings against Trump have been targeted by his invective. Those risks have the potential to undermine the integrity of the proceedings as well as jeopardize the safety of law enforcement. The court has previously underscored its independent obligation to protect the integrity of this judicial proceeding, and the court has the power and responsibility to impose additional or different conditions of release. Under 18 U.S. Code Section 3142, sub C, sub 1, sub B, sub 14, that are reasonably necessary to assure the safety of any other person in community. 18 U.S.C. Section 3142, sub C3. a condition of release that prohibits the defendant from making statements posing a significant, imminent, and foreseeable danger to law enforcement agents participating in the investigation and prosecution of this case is warranted and necessary here. Such a prohibition will also minimize further prejudice caused by the defendant directing false and inflammatory messages regarding the facts of this case to potential jurors who may be summoned by the court for jury service in this matter. Background. As explained in more detail in other filings, the government applied for a warrant to conduct a search of Mar-a-Lago for documents with classification markings, and a United States magistrate judge in this district granted the application and issued a warrant on August 5th of 2022. The magistrate judge found probable cause that evidence of the 3 crimes: willful retention of national defense information, concealment or removal of government records, and obstruction of a federal investigation would be found at Mar-a-Lago. In preparation for the execution of the search warrant, the FBI created a law enforcement operations order using FD 888 form, as is typical in every case. The FBI planned to execute the search warrant as unobtrusively as possible, communicating and coordinating with Trump's representatives throughout the time that they were on his premises. The FBI chose a date, August 8th of 2022, during Mar-a-Lago's off-season when neither Trump nor his family would be in Florida. Under the plan that the FBI prepared, prosecutors and agents would contact Trump's retained counsel before the warrant was executed to notify him of the search warrant and request collaboration and assistance. The FBI would then coordinate with the U.S. Secret Service and, if necessary, with Mar-a-Lago Guest Services to ensure a fulsome understanding of spaces occupied as designated in the search warrant. And then see section on coordinating instructions, listing plans to coordinate with the Secret Service as well as other LE agencies and Mar-a-Lago security and staff. Execution occurs during the off-season date range. In the section of the operations form addressing contingencies, the FBI noted that if, contrary to expectations, Trump and the Secret Service were to arrive at Mar-a-Lago while the search warrant was being served, FBI management would be prepared to engage with points of contact with the Secret Service per existing liaison relationships. FBI policy requires that special guests must be armed when on business, thanks VC, when on official business, unless dictated by operational necessity, and are encouraged to be armed at all times. In keeping with that policy, the operations form provided that the FBI agents who conducted the search and would carry standard issue weapons and be attired in business casual with unmarked polo or collared shirts, and law enforcement equipment concealed. The operations form also included a section, again, standard in every case, entitled Policy Statements Use of Unaliving Force. That section stated, among other things, that law enforcement officers of the Department of Justice may use unaliving force only when necessary, that is, when the officer has a reasonable belief that the subject of such force poses imminent danger of unaliving or serious physical injury to the officer or another person. Tea break. Thanks, Beverly. Thanks for reminding me. Some are scheduled, but it's very rare. It's very rare. It's only in very special cases where you have a very, it's not like it was a real forcible kind of situation. It was a very understandable, blasé situation. The policy statement further provides that officers should seek to gain voluntary compliance before using force if feasible, and if doing so would not increase the danger to the officer or others. This language repeated general FBI policy for use of unaliving force, cited here. FBI special agents may use unaliving force only when necessary, when the agent has a reasonable belief that the subject of the force poses an imminent danger or unalive of serious physical injury to the agent or another person. The FBI executed the warrant as planned on August 8th of 2022. Prior to the Federal Bureau of Investigation's team's entry onto the Mar-a-Lago premises, FBI leadership informed and coordinated with the local Secret Service leadership. and local Secret Service facilitated entry onto the premises, provided escort and access to various locations within, and posted Secret Service personnel in locations where the FBI team conducted searches. The FBI also contacted Trump's attorney before beginning the search of the premises. As anticipated, neither Trump nor any of his family members were present at the time of the search. At no point were any weapons drawn. So I'm just pausing for a moment. So Secret Service is always on his properties then, even if he and his family are not there? I'm not sure if I knew that or not. Maybe they just have a limited skeleton crew running. Interesting. After the grand jury issued the indictment in this case, the government produced the warrant and the operation form to Trump and the other defendants in discovery. There was nothing unusual about the use of an operations form containing the department's policy statement. Policy statement on the use of unaliving force. To the contrary, the same form containing the same policy statement is regularly used in searches throughout the country. On February 22nd of 2024, Trump filed under seal a motion to suppress evidence obtained through the search of Mar-a-Lago. So that's what we just, February 22nd, filed under seal a motion to suppress. In setting forth what he described as relevant facts, Trump stated that the operations form contained a policy statement regarding use of unaliving force, which stated, for example, law enforcement officers of the Department of Justice may use unaliving force when necessary. Although Trump included the warrant and operation form as exhibits to his motion, the motion misquoted the operations form by omitting the crucial word only before when necessary, without an ellipsis reflecting the omission. The motion also left out language explaining that unaliving force is necessary only when the officer has reasonable belief that the subject of such force poses an imminent danger of unaliving or serious physical injury to the officer or another person. Notwithstanding the misleading characterization of the use of force provision when describing the search, the motion did not seek suppression based on the policy claim that the agents had acted inappropriately in following the standard protocol or otherwise rely on the policy as part of the argument. On May 21st of 2024, Trump filed a redacted version of his suppression motion in exhibits on the public docket. All right, and that's what we just read, everyone. The next day, Trump publicly claimed that he was just shown reports that crooked Joe Biden's DOJ and their illegal and unconstitutional raid of Mar-a-Lago authorized the FBI to use unalived lethal force. Trump also sent an email stating that the government was authorized to shoot me was just itching to do the unthinkable and was locked and loaded, ready to take me out and put my family in danger. Trump also publicly claimed that, shockingly, the Department of Justice authorized the use of unaliving force in their illegal, unconstitutional, and un-American raid of Mar-a-Lago, and that would include against our great Secret Service who they thought might be in the line of fire. Predictably, and he certainly intended, others have amplified Trump's misleading statements, falsely characterizing the inclusion of the entirely standard use of force policy as an effort to assassinate Trump. I know, it really is something. Discussion. The court should modify Trump's conditions of release to reasonably assure the safety of any other person or community, and to implement the court's independent obligation to protect the integrity of this judicial proceeding. Professional law enforcement officers and agents in this country put their lives on the line every day in carrying out their duties to enforce the law. When executing court-authorized warrants, those professionals face many uncertainties and potentially grave risks. To minimize the threat of harm to law enforcement professionals and civilians, agents plan carefully for all contingencies. They also follow standard policies and protocols, including the prohibition of using unaliving force except when necessary. The FBI followed these entirely standard and appropriate practices here. Trump, however, has grossly distorted these standard policies by mischaracterizing them as a plan to unalive him, his family, and the U.S. Secret Service agents. Those deceptive and inflammatory assertions irresponsibly put a target on the backs of FBI agents involved in this case, as Trump well knows. Indeed, Trump himself recognizes the power of his words and their effect on his audience, agreeing that his supporters listen to him like no one else. quoting a transcript of the CNN's town hall. And his documented pattern of speech and its demonstrated real-time, real-world consequences have often posed significant, imminent, and foreseeable threats to witnesses, particularly whereas here they include deceptive and inflammatory claims. Collecting examples of those inflammatory claims are set out in pages 1010 through 1012. Those risks have justified restrictions on Trump's extrajudicial speech and other proceedings precisely to prevent threats, harassment, and other harms that undermine judicial proceedings. Indeed, an armed attack on the FBI office in Cincinnati, Ohio, was carried out by one of his supporters in the wake of Trump's Truth Social statements, inflaming his supporters regarding the search of Mar-a-Lago. And we have footnote 3 here. Cincinnati statement, August 11th of 2020, is available here. Gunman unalived after trying to breach FBI office in Ohio, authorities say. That was a Washington Post article here. Under the Bail Reform Act, a judicial officer shall issue an order that pending trial, the defendant be either released on personal recognizance or on unsecured bond, released on a condition or combination of conditions under Section C, or temporarily detained pending revocation, deportation, or exclusion, or detained. Here, Trump was released on conditions under subsection C. Subsection C provides that if a person is released on conditions, the judicial officer shall order the pretrial release of the person, subject to 1, the condition that the person does not commit a federal, state, or local crime during that period of release, and which has been a lot of the questions, everybody, when he's been holding a weapon. There have been some issues about that. Sorry, everyone, I've got to move my chair over. I was losing my screen. There we go. And 2, the least restrictive further condition or combination of conditions that such judicial officer determines will reasonably assure the appearance of the person as required and the safety of any other person in the community. It is very well written, I would agree. The statute then lists several further conditions that the release order may include. As relevant here, those further conditions include that the defendant satisfy any other condition that is reasonably necessary to assure the appearance of the person as required and to assure the safety of any other person and the community. Subsection C further provides that the judicial officer may at any time amend the order to impose additional or different conditions of release. The court should exercise its authority to impose a condition that Trump may not make public statements that pose a significant, imminent, and foreseeable danger to the law enforcement agents participating in the investigation and prosecution of this case. Whether a particular statement meets that test must be determined by reference to the statement's full context. But that condition would clearly prohibit further statements deceptively claiming that the agents involved in the execution of the search warrant were engaged in an effort to unalive him, his family, or Secret Service agents. As such, the condition is sufficiently clear and specific to serve as a guide for the person's conduct, and it gives sufficient warning that he can conform his conduct to the law and avoid that which is forbidden. This modification would only fully comport with the First Amendment. Like any other criminal defendant, Mr. Trump has a constitutional right to speak, and his millions of supporters, as well as his millions of detractors, have a right to hear what he has to say. Also, like any other criminal defendant, Mr. Trump does not have an unlimited right to speak. To the contrary, pretrial release conditions commonly include measures that burden criminal defendants' ability to act, associate, and speak. For example, the restriction that a defendant avoid all contact with a potential witness who may testify concerning that offense. So let me turn, and this is the last page here of the motion, everyone. Is so commonplace that Mr. Trump does not dispute the court's authority to have ordered him as a condition of pretrial release not to communicate with witnesses except in the presence of counsel. Courts overseeing criminal cases must also take such steps by rule and regulation that will protect their processes from prejudicial outside interferences. Prejudicial outside interferences can include pretrial statements by participants in a criminal case, which may be restricted when, as here, they pose a substantial likelihood of material prejudice to the proceeding. And even if a more demanding level of scrutiny were to apply, the proposed condition of release would be entirely permissible because it reaches only statements that pose a significant and imminent threat to the administration of criminal justice. Trump cannot evade this legitimate limitation by dressing up inflammatory messages, such as those in political speech garb. Moreover, because the source of foreseeable endangering statements covered by the proposed condition cannot be remedied through measures like voir dire, no less speech restrictive alternative could viably protect against the significant harms created by this aspect of Trump's speech. Here's the conclusion. The law enforcement agents participating in this case conducted the search in an appropriate and professional manner, subject to the Department of Justice's standard use of force policy. Trump's repeated mischaracterization of these facts and widely distributed messages as an attempt to harm him and his family and Secret Service agents has endangered law enforcement officers involved in the investigation and prosecution of this case and threatened the integrity of these proceedings. A restriction prohibiting future similar statements does not restrict legitimate speech. Trump's conditions of release should therefore be modified to prohibit similar conditions going forward. Okay, everybody. With that, let me go check real quick and see. The response hadn't been posted at the time. So let me go check real quick and see if I can print out a response. Oh my gosh, come on. Are you kidding me? Oh my goodness. What? Oh my goodness. All right, everybody. All right, he has filed a motion to strike and sanctions. Oh my goodness. Oh, all right, it's printing out right now. Let me go grab it. Oh my goodness. Oh. All right, here we go. I'm telling you, there's something not right about that Todd Blanche fella. Something not quite right with that guy. This is, ooh, nope. It sounds like 50, but it's not. Nope. There's an exhibit that's attached to the end of it. So here we go. Yes, so this will be the defense response. Let's see if I can write this down. So this is the defense's response to the motion for a gag order. Oh my goodness. All right. Oh, thank you, Lori. Response to gag order request. All right. Oh my gosh, everybody, the toner. I'm so thankful. I had to get a whole nother, I had to get a new drum too. That was my first time getting a new drum. But yikes, I'm very thankful for that. Yes, indeed. Thank you, everybody, for your contributions. Oh, my goodness. Yes, I've gone through so many. It's just on auto ship now. Oh, my gosh. All right. Drums they are expensive. They are. The toner and the drums are expensive. All right. So it's the least we can do. Oh, thank you so much. Thank you, everybody. Oh, I appreciate it. All right, let's dive into this and crack this open. Oh my gosh. All right, everyone. So we've got Trump's response to the gag order. I'm just trying to make sure I'm in frame. I've got a couple different screens here. Oh my gosh, thank you. Thank you, everybody. All right, am I in frame okay, everybody? Oh, thank you. Oh, I know. I've got, yeah, some, oh my goodness. Oh, yeah. Let me see if I can get my, I got to get my teacher pen out. All right, so I've got all the colors here. All right, excellent. Here we go. President Donald J. Trump, again, we know it's his motion because he calls himself that, motion to strike and request for sanctions based on the special counsel's May 24th motion. Oh, my goodness. All right, President Donald J. Trump respectfully submits his procedural opposition to the May 24th, 2024 filing by the special counsel's office, which improperly asked the court to impose an unconstitutional gag order on President Trump as a condition of his pretrial release, based on vague and unsupported assertions about threats to law enforcement personnel whose names have been redacted from public filings and whose identities are already subject to a protective order. And then we've got our footnote number 1 here. On May 26th, we were notified that special counsel's office via email that we plan to file this application. The office responded that they oppose the relief we are seeking. We reserve the right to oppose the motion on substantive grounds after the motion is filed in a procedurally appropriate fashion, following meaningful conferral with defense counsel. What? Wow. All right. And so the exhibit that's attached is a string of emails. For the reasons set forth below, in the light of the office's blatant violation of Local Rule 88.9, oh my gosh, and related warnings from the court should strike the motion, make civil contempt findings as to all government attorneys who participated in the decision to file the motion without meaningful conferral, and impose sanctions after holding an evidentiary hearing regarding the purpose and intent behind the office's decision to willfully disregard required procedures. Oh my gosh, oh my goodness. This is awful. Oh dear. Goodness gracious. All right, here we go. Following a string of procedural abuses and misrepresentations over the course of many months, whoa, that's harsh. At a May 22nd hearing on pending pretrial motions, the court admonished the special counsel's office to just calm down. Far from it, the office contacted defense counsel about filing the motion at 5:30 p.m. on Friday evening before Memorial Day weekend, as President Trump and counsel prepared to deliver the defense summation in People v. Trump on the morning of Tuesday, May 28th. We responded immediately, but the office declined our request to discuss the motion on Monday, May 27th, so that we could meet with our client beforehand, and the office did not specifically identify any evidence cited in the motion until about 15 minutes before filing. As with prior filings by the office, the motion fails to identify any direct evidence of the purported safety risks they claim exists. The office did not even dare seek emergency relief in the filing, as no such relief is warranted. Thus, there's no basis for rushing to file the motion on Friday night. This is a bad faith behavior, plain and simple. The misconduct by the special counsel's office is even more worthy of sanctions in light of the context. The motion is extraordinary, unprecedented, unconstitutional censorship application. Oh my gosh. I mean, they cited Trump's own cases. The motion unjustly targets President Trump's campaign speech while he is the leading candidate for the presidency. The motion also treads new, extremely problematic ground as a requested prior restraint that's different in kind from the unconstitutional gag orders that the prosecutors have sought in New York and Washington, D.C. Specifically, the office seeks to condition President Trump's liberty on his conformance with the views of Jack Smith and Smith's associate about what constitutes appropriate argument based on the record in this case, and to require the probation office and the court to mediate disputes against a backdrop of potentially imprisoning a political opponent who is successfully defeating Smith's boss and preferred candidate. This is awful. This is just awful. Oh my goodness gracious. Oh my gosh, what a... All right, here we go. I gotta pull myself together, everybody. This is awful. All right, for purposes of this application, that all matters because there can be no reasonable dispute that the issues raised in the motion are, to put it mildly, complex. Pursuant to the local rules, the special counsel's office was required to meaningfully confer with us regarding those issues prior to filing the motion. They did not. Indeed. Instead, they persisted with a troubling pattern of pursuing media coverage rather than justice. Such an approach by prosecutors formed to uphold the law should have no place in your honor's courtroom. Such an approach requires consequences to ensure fundamental fairness, and that is what we are seeking here. Oh my gosh. I'm going to have extra tea, everybody. Background. The refusal to meet and confer. So I'm getting like, you didn't listen to us well enough vibes is what I'm getting here. Drama. I know, boo, get off the stage. Right. Refusal to meet and confer. At 5:30 p.m. on Friday, May 24th of 2024, the special counsel's office emailed defense counsel stating that they intended to file the motion. At the conclusion of the email, Jay Bratt asserted, "We plan to file the motion later this evening. If you would like to discuss further, please let us know." 10 minutes later, at approximately 5:40 p.m., defense counsel notified the special counsel's office that we objected to the timing and request in the filing of the motion. We noted the suspicious timing of the communication, the court's prior warnings regarding the need for meaningful conferral, and the fact that there was no basis for the office's suggestion that anyone faced imminent danger. We notified the office that we were unavailable to meet and confer until Monday afternoon, which would allow time to meet with our client and discuss whatever position we believe appropriate. The special counsel's office responded approximately 1 hour later at 6:45 and referred to conferral as a fruitless exercise. It sounds a little bit like a divorce situation, everyone. Are we having some it's more like a family law situation, in my opinion. Bratt made vague reference to alleged statements by President Trump on May 21st, May 23rd, May 24th, and suggested that filing the motion after business hours on the Friday of a holiday weekend would somehow mitigate the completely unsubstantiated dangers the office contends exist. At 6:55 p.m., defense counsel notified the special counsel's office that we viewed the office as having completely failed to meet and conferred. We pointed out that the office still had not specifically identified the alleged statements that caused them concern. We added accurately that the local rule requires you to do more than just inform us of something was said, and based on that statement and prior positions of our client, you assume we would oppose. Finally, concerned that the office planned to file the motion despite the local rules, we asked the office to include a detailed statement regarding President Trump's position. Oh my gosh, this is going to be so good, everybody. This is his position, and they didn't include it in their motion. All right, are we ready? Oh my goodness gracious. All right, here we go. This is what Mr. Trump had wanted them to include, but they did not include it. Now they're mad about it. Could you slide the page to the left? Yes, there we go. How's this? Are we better? Here we go. Quit crying. All right. Please include the following position from us in your motion, which, by the way, is not required. At 5:30 p.m. on Friday evening, the special counsel informed us that they were seeking to modify President Trump's bail conditions based on as yet unidentified statements purportedly made by President Trump on Truth Social and in fundraising emails. They indicated that they were filing the motion tonight without informing us of the statements that they claimed give rise to the relief sought, and without allowing defense to respond as required under local rules. Defense counsel has had no opportunity to confer with the special counsel's office, nor have we had an opportunity to confer with our client about the requested relief. But I thought they just said this is President Trump's position. Defense counsel indicated its availability over a holiday weekend on Monday, a holiday. The special counsel refused its good faith effort. This is a blatant violation of SD, so Florida law, local rules, and prior orders of this court. We oppose this motion being filed in this format and ask that it be summarily dismissed because of the lack of effort to meaningfully meet and confer. Oh my gosh. Oh my goodness. In response, the special counsel's office demeaned counsel. Oh my God. Well, that's not appropriate. You should never be doing that. That is not appropriate. I'm only laughing because it's so not appropriate. All right. Demeaned counsel and mocked the assertion that the office should specifically identify the statements that served as the basis for the motion. In Bratt's view, it was incumbent on the defense to discern the social media posts and campaign emails that the office would rely upon to seek unconstitutional restrictions on President Trump's First Amendment rights. Bratt nevertheless attached. Yeah, they seem really hurt by this lack of communication. I feel like there's some communication issues going on here. Communication to a 7:45 email. Make sure I'm in frame here, everybody. He also informed the defense that he would not include our position in the office's filing, but claimed that he would fairly summarize it. The special counsel's office filed the motion 15 minutes later. The office failed to note that they first contacted the defense about the motion at 5:30 and that they declined our invitation to discuss the issue on Memorial Day. Despite attaching certain alleged statements to the 7:45 email, Bratt did not even attempt to confer regarding Exhibit 4 to the motion, which we learned of for the first time after the motion was filed. Yes, exactly. Exactly right. I think that's accurate. Number 2, previous disregard of procedural rules by the special counsel's office. All right, this should be good. On July 18th of 2023, all right. So we're going way back, everybody. We're going way back. We're going in a time machine. The court denied without prejudice a motion by the special counsel's office for lack of meaningful conferral. In 2023, what? Transcript. The court. All right, so you tried to confer on a Friday before filing on a Monday, something that's presumably quite important. That seems a... Transcript. The court. All right, so you tried to confer on a Friday before filing on a Monday, something that's presumably quite important. That seems a bit... Okay. In addition to ongoing misrepresentations regarding the status and timing of discovery, the special counsel's office has repeatedly made meritless arguments seeking sealing and ex parte proceedings. Here's our footnote here, too. The government's motion does not explain why filing the list with the court is necessary. It does not offer a particularized basis to justify sealing the list from public view. It does not explain why partial sealing, redaction, or means other than sealing are unavailable or unsatisfactory. And it does not specify the duration of any proposed seal. Okay. So, oh my goodness gracious, everybody. All right, here we go. The court warned the office about making sweeping and, trying to make sure I'm in frame here, everybody, and unsupported claims and failing to substantiate their assertions concerning, among other things, witness safety. And then last month, the court found that the office had failed to offer a governing legal framework or any factual support for relief sought in connection with sealing requests relating to defendants' motion to compel discovery. Instead, it contained only conclusory and unsubstantiated assertions about witnesses' safety, the integrity of the proceedings, and privacy interests. The court also warned the office about giving short shrift to the First Amendment, where they failed to engage with, let alone refute, the Press Coalition's argument that the First Amendment attached to the subject materials. The special counsel is not campaigning for any office. Well, I mean, so far as we are aware, but his prosecutors have pandered to the media in public filings. This has included gratuitous and prejudicial language in the superseding indictment, which Bratt recently admitted was presented based on Federal Rule of Evidence 404B, despite its disputed admissibility. What even is this? Oh my gosh. The court, that's not generally the format and the purpose of an indictment. The office has also included lengthy explications of purported facts in public filings to set the record straight before turning to those arguments from the defense that are actually being litigated before your honor. Attorney General Garland, wow. All right, am I in frame? Hold on, everybody. Sorry. Here we go. I'm going to just bump this up here. See if I can stay better in frame. Okay, thank you. Attorney General Garland behaved in a similar fashion through extrajudicial statements in a January 2024 interview, arguing that a speedy trial was necessary while the court was evaluating whether schedule modifications were needed in response to the office's discovery failures and related misrepresentations. These tactics have also included a public filing threatening your honor with frivolous mandamus litigation. Oh my gosh. Whoa. Oh my gosh. All right. Whoa. And a lawless interlocutory appeal concerning hypothetical jury instructions. Whoa. The import of this behavior was plainly not lost on your honor, and the court appropriately described the office's contentious as unprecedented and unjust. Oh my gosh. Oh, wow. On May 19th of 2024, the court deemed it necessary to express concern over the special counsel's treatment of certain sealed materials in this case. The court's concerns included the office's argument that some unsealing was appropriate in order to publicly and transparently refute defense allegations of prosecutorial misconduct, but other sealing of similar materials was necessary to simultaneously preserve the witness safety, and Rule 6E concerns the office has repeatedly told the court and maintains to this day are of serious consequence. The court noted that it was disappointed with the office's failure to seek sealing in a manner that could be applied consistently and fairly upon a sufficient factual legal showing, and instructed that the parties should not make requests that undermine any prior representations or positions. Wow, this is like, ugh. All right, here we go. All right, just making sure I'm in frame. Finally, just last week, in response to a troubling show of tone and demeanor at a hearing in your honor's courtroom, the court admonished David Harbach to just calm down, citing the transcript. What's happening in Florida? What's going on? Oh my gosh. All right, applicable law. Local Rule 88.9A requires, at the time of filing motions in criminal cases, counsel for the moving party shall file with the clerk of court a statement certifying, 1, the counsel has conferred. I'm going to skip through the applicable law here, everybody. All right. This is where they're saying the rules say that they're supposed to have meaningful conference. All right. So I'm going to skip through this legal section because I do not know if they are correctly writing it. All right. So let's get to the discussion piece. Oh my gosh. Well, that's an interesting point, Momo. That's an interesting point, and you may not be wrong. All right, let me make sure. Here we go. Discussion. The special counsel's office violated the local rules by filing the motion. The court has warned the office about this issue specifically and more generally about a pattern of unprofessional conduct in this case. Whoa, that's really, oh wow. In order to deter such behavior as the case proceeds, the court should strike the motion, make civil contempt findings as to all government attorneys who, wow, oh my gosh, participated in the decision. Hold on here, everyone. Oh my gosh, this is really awful. This is terrible. Yeah, this is pretty absurd. Participated in the decision to file the motion without meaningful conferral and impose sanctions following an evidentiary hearing relating to the office's motives and purpose in filing the motion when they did. Wow, that's so out of line. That's so out of line. Under no circumstances can an email exchange initiated at 5:30 p.m. on a Friday evening constitute the type of conferral required by Local Rule 88.9. For President Trump, the fact that special counsel's office initiated the exchange on Friday preceding a holiday weekend is less important than the fact that the office, well aware of the proceedings in People v. Trump, took these steps when President Trump's defense summation scheduled to begin on the morning of May 28th. I'm going to pause here and say I don't have a lot of sympathy because you've got too many criminal trials going on. I just don't. I don't have a lot of sympathy for that. I'm just going to put that out there. Despite that schedule, defense counsel offered to consult President Trump over the weekend and to discuss the motion with Bratt and Harbach on Memorial Day. The office barely acknowledged the request. The failure to meaningfully confer is even more troubling in light of the fact that the parties were assembled before the court on Wednesday on May 22nd, making their own rules for the judge. Yeah. The special counsel's office cites the motion on May 21st of 2024 social media post by President Trump. The office truly believed that President Trump's constitutionally protected speech posed the type of threat that they claim in the motion. Then they should have discussed the issue with counsel in person rather than raising it via email on a Friday evening 2 days later. This timing is not justified by exigent circumstances following the May 22nd hearing. Consistent with prior inaccurate claims, the special counsel's office has failed entirely to substantiate the argument that President Trump's campaign speech posed a significant, imminent, and foreseeable danger to law enforcement agents participating in the investigation. And, oh my goodness gracious, everybody. I think somebody here is a little bit upset about what's going on in New York, and I think they're taking it out on the lawyers in Florida. Prosecution of this case. As we have noted throughout, President Trump and the defense team have great respect for law enforcement agents who do their jobs with integrity. Yikes. We have not and will not stand in the way of credible assertions about potential for safety risks to such individuals. On the other hand, we will not acquiesce to unsupported histrionics from biased and reckless prosecutors who have shown no respect for the First Amendment, other constitutional protections, the local rules, and the court's orders. Yikes! The court is well aware of the prosecutors' failures in this regard because of the extraordinary amount of attention has been devoted to the arguments by special counsel's office regarding the need for sealing to protect witness safety. Defense counsel conferred extensively regarding redactions to President Trump's pretrial motions, including his suppression motion. That process resulted in consented to redaction of identifying information relating to potential witnesses, including agents who participated in the August 2022 raid at Mar-a-Lago. We invited the office to propose other redactions as they believe necessary or appropriate. At no time did the prosecutors seek redactions relating to the use of force information in the operations order concerning the search or discussions of that order in our motions papers. To our knowledge, the unsealing of these materials did not result in credible safety risks to anyone. The special counsel's office presented no actual evidence of safety risks in the motion either, especially after the office's complete failure to substantiate safety claims in connection with the sealing applications. Their failure to submit an affidavit supporting their arguments is troubling. I think it's an interesting point, everyone, that the papers and the words on the papers were okay, but it wasn't until Mr. Trump kind of, mixed them up and spewed them out on his social media, then it became a problem. So the argument would be, well, we didn't have to say anything because the paperwork was fine. It was your client talking about it that made it harmful. That would be the argument. There was no basis for the office to suggest that some sort of emerging risk required filing the motion just after 8 p.m. on Friday rather than speaking with defense counsel on Monday. No one who signed the motion, I think he's forgetting about Saturday and Sunday, because he's like, oh, Friday night, and we were available on Monday, but there's 2 days in there, right? Could reasonably have expected the court or its staff to act on the application before business hours resume on Tuesday, nor could Smith himself. Rather, the office plainly filed the motion in pursuit of some other objective, which has not yet been identified but must be determined in order to craft appropriate sanctions for this most recent violation of the rules. Yikes. For example, the motion's not styled as an emergency application pursuant to Local Rule 7.1D. As a result, Smith and his team could not possibly have expected the court to act on the motion over the weekend. Moreover, there is no indication in the motion that the office discussed the application with the probation office, which would be required to help enforce the patently unconstitutional modification the office is seeking. In addition, the Bail Reform Act does not contemplate such a modification absent a hearing, and not even Smith and his team dared suggest the court convene the parties on Memorial Day weekend to address it. Wow. Indeed, the local rules and basic professional norms contemplate that President Trump would be afforded a reasonable amount of time to respond to the motion in writing. Despite their strained and inaccurate claims regarding urgency, the office did not seek an expedited briefing schedule based on their purportedly exigent safety concerns. All of this to say the timing of the motion reflects bad faith behavior by everyone who is associated with filing it. Wow, everybody, this is pretty awful. Finally, while we do not here address the merits of the motion, a few preliminary points are in order. One of the senior officials who authorized the raid, and I'm not going to actually get into this piece at this point in time because I'm looking at the clock here, everyone. Hold on, let me see if I can just fast forward. Just a minute. Okay. Well, actually, we're only a page out. We're literally 1 page out. So let me go ahead and finish it up. I'll go ahead and finish it, everyone, because this is just 1 more page. I was like, if this is 10 more pages, I can't do it. I just can't do it. All right. Finally, while we do not here address the merits of the motion, a few preliminary points are in order. One of the senior officials who authorized the raid at Mar-a-Lago said he frankly doesn't give a damn about the optics. But now the special counsel's office seems to care about those optics very much. The motion quotes liberally from the D.C. Circuit's review. Again, I'm just trying to make sure I'm in frame here, everybody. A review of the separate unconstitutional gag order in the District of Columbia fails to address one of that court's key points. Working in the criminal justice sphere fairly requires some thick skin. Interesting. That Smith is once again attacking President Trump's protected campaign speech is conclusively established by the fact that the special counsel's office attached a campaign email to the motion. Once disfavored, but now in vogue for prosecutors driven by political animus against President Trump, gag orders reflect an extremely serious threat to our constitutional traditions, especially when they are applied to political candidates. It doesn't seem that way. It's like there's only one person that this is applying to. The motion goes one step further, however, in seeking to condition President Trump's liberty on his compliance with the views of Smith, Brat Herbach, and the other self-appointed thought police regarding what constitutes fair argument to the American people by the leading candidate in the 2024 presidential application. In that regard, the motion is an unprecedented application, and the abuses that it reflects are manifest. If and when there is an appropriate time, we will forcefully address the motion on the merits. Oh my gosh. However, The point of this application is that the motion should not have been filed Friday night. The decision by the special counsel's office to do so, when it did so, cannot be explained in a manner that is consistent with the need for prosecutorial ethics and public confidence in proceedings. In order to craft appropriate sanctions, the court should conduct an evidentiary hearing to determine why the office chose this wrongful path. Wow. In addition, the bias and animus that are evident from the office's recent course of action are relevant to the pending motions to dismiss based on selective and vindictive prosecution as well as prosecutorial misconduct. Yikes! Citing Armstrong, reasoning that selective prosecution discovery includes all evidence in the government's own files. My goodness gracious. So here we go. For that reason, too, the court should make evidentiary determination regarding the office's intent in connection with the prosecutor's continued disregard of the local rules and the court's prior warnings. Conclusion. For the reasons stated herein, the court should strike the motion and make civil contempt findings to all government attorneys who participated in the decision to file the motion without meaningful conferral and impose sanctions after holding an evidentiary hearing regarding the purpose and intent behind the office's decision to willfully disregard required procedures. Yikes. Yeah. There's something wrong with that guy. Something wrong with that fella. Wow, everybody. Wow. This is so out of line. So out of line. Like if we were in a civil case and we're fighting back and forth, that's one thing. But to call like the prosecutors a thought police and claim that this gag order is, I mean, it's only for Trump. It's only because of Trump, because he can whip up some of the people and cause harm. So, like, for goodness sake, oh my gosh, I don't even know what to say about this. What does that all mean? It means that, right, well, I think that, I think it means his attorneys are big jerk faces. I think that's kind of what it means. There's something wrong with Olive. Yes, he is dangerous. Come on. I'm not sure she's in his pocket, everybody. We'll see. I mean, what her response is to this, I think will tell us a lot. If she comes in and takes a look at this and somehow tries to support it, I would have some questions at this point because this is like full-blown garbage. Can you explain why a Friday filing is unconstitutional? It certainly is not unconstitutional. It certainly is not. And in D.C., we've had Friday nights, Saturday nights, Sunday nights. I mean, Trump himself, his team filed one like Sunday at 5:45 p.m., like that had to be responded to, There's nothing unconstitutional about it. I don't know either. Jack will appeal. Yeah, well, I mean, we'll see. He's got to wait for a decision from her before he can appeal. Yeah, I went after E.G. and I saw that, Dora. I saw that. Interesting. Go to the chief judge and request removed from the case. I don't know. Watch for it. I do not. Well, I understand. We've got some trust issues with Judge Cannon, understandably so. I can understand that, but we will see. Oh, I don't know that this isn't necessarily a delay situation. Yeah, I don't know. How much does it take? How much money does it take? I've got my suspicions. But for you to turn from one of the good guys to one of the bad guys. And that, I think, is what's happened with Mr. Blanche. And I don't say that lightly, based off of my own ethics as an attorney. And in my opinion, I think it takes, some serious cash in a home in Florida. I really, and a promise of a cushy job. I really think he was just given that golden ticket and was willing to sell his soul. That's how it seems. How long does she have to respond? It's really up to her. You have only a certain period of time to respond to any motion. So I'm not sure exactly how many days it is, but they respond. She'll respond pretty quickly to requests of this nature, in my opinion. Auditioning for AG, oh my gosh, of Florida? Oh, I don't know. Could also depend on their client, true, but at this point, there's something weird going on. If this was like a movie, I would say that these these guys are like somehow they've been like brainwashed and they're like hypnotized into being like the bad guys. Or maybe they were pretending to be the good guys, but in the reality, they've always been the bad guys. I don't know. There's something wrong with them. There's something wrong with them. There's something wrong. Or the only other thing I could think of too is that Mr. Blanche has got some kind of skeletons in his closet, and those have been found. And so at this point, Mr. Blanche is like, I might as well, join the dark side because I'm already going down too far. I know. Scooby gets on the case, Scoobs. I know. I know. I know. It's so weird to have this much of a dramatic change in your in your ability. Like he was either slime to start with, or he's decided that he's gonna throw his chips in with the slimies. So, and there were always a few slimy people in law school. And there's slimy lawyers all over the place, but this Blanche fella, he didn't seem to start off slimy. It just seems to be like something that he's really grown into. Like he's gotten a little taste for power, and he's like, oh, I'm going to be like the king of all the slime balls. Like, all right, dude. Rush has something on him. Could be. Could very well be. Could very well be. We've got a lot of secrets going around. See, that's why, everybody, this is what happens when you do bad things. They can come back to you if you don't take care of them properly, He was slimed by Trump. Power most certainly does corrupt. Absolutely. It certainly does. So I've got no idea. Well, no respect. Well, yeah, I mean, I don't know. I don't know. I just don't know. Some of those higher position jobs, they're good, but a better job is when you get paid a lot of money, you don't have to do a lot. So I don't know. It's tough. Like the mafia. I agree. All right. With that, everybody, I've been on for a really long time tonight. So I will. Yes, there's this whole string of emails here, and I won't be able to read them tonight. But if you go online and look for this motion yourself, you will be able to pull these emails up. So, oh my gosh, thank you so much. You're so sweet. I appreciate your support so very much. But yeah, there are some emails here. I will go ahead and sign up for tonight, though, everyone. Thank you so much for coming and hanging out with me for so long tonight. We were able to kind of catch up on this Florida case and see what's going on. Now, I will be off tomorrow, but I will be back again on Wednesday. So watch out for me on Wednesday, everybody. I'm hoping to be able to come back and finish up all of the New York information on Wednesday. And we will, of course, be waiting for a verdict for the rest of this week. So have a wonderful night. Thank you so much for your support, everybody. And I really appreciate it. So have a great night. I will be back as soon as I can. Take care, everyone.